Welcome to this second episode of the Binary Agora. In this series, we dive deep into the world of legal tech, breaking down its challenges, innovations, and their real world impact with insights from top researchers. Today, I will discuss the latest developments regarding the DMA's compliance. On 6 March 2025, the designated gatekeepers under the DMA had to submit their compliance reports detailing how they complied and how they implemented the regulation. In this episode, I will dissect the second wave of DMA compliance reports from the six designated gatekeepers. Gatekeepers must adhere to the reporting obligations under the DMA. The key provision here is Article 11 of the DMA, which requires them to submit two types of compliance reports. First, a confidential detailed report to the Commission outlining the compliance measures for obligations under Articles 5, 6, and 7. And second, a non-confidential version made publicly available on the European Commission's website, allowing stakeholders, competitors, and also the general public to assess these compliance efforts. And that's exactly what we'll be reviewing today. Beyond Article 11's general obligations, the European Commission issued the Compliance Report Template form, which further refines what the reports must include, since the provisions may be at some times too abstract to apply in practice. The European Commission has the power to do that under Article 46(1)(f) to issue implementing acts that clarify vague regulatory provisions, and that's precisely what happened here. As a result, all reports submitted by the gatekeepers follow a standardized format. But interestingly, the template also adds extra reporting elements that aren't explicitly stated in the DMA itself. For instance, gatekeepers must also disclose which metrics they use to assess compliance with the DMA's overarching goals of contestability and fairness. The template crucially also shifts the reporting timeline. Instead of only submitting an annual update, as Article 11 of the DMA requires, the template establishes that gatekeepers must compare their measures with the pre or post designation scenario. Following the words of the template, that would mean that every single compliance report should perform a comparison between the initial compliance deadline, in this case 7 March 2024, and the subsequent measures adopted thereof, regardless of the number of reports the gatekeeper has previously submitted. And this raises a key question. Should compliance always be assessed against the status quo before the DMA, or should regulatory standards evolve over time, making incremental compliance improvements necessary? Gatekeepers' compliance strategies do not quite offer a straightforward answer to those questions because comparing the two waves of compliance reports, we see different approaches. According to Article 11, gatekeepers must submit at least one compliance report annually. This would suggest a forward-looking approach, tracking compliance on the 7th, from the 7th of March of 2024 onward. But the template seems to require a retrospective comparison. On this same note, last year the gatekeepers took different stances. Amazon, ByteDance, and Meta claimed full compliance by the 7th of March of 2024 without rolling out substantial technical challenges afterward. There is, however, nothing inherently contrary to the DMA with this compliance strategy. Meanwhile, Apple, Alphabet, and Microsoft outlined both their technical implementations up to the compliance deadline, and it also set up the steps that they planned to implement for future compliance. Essentially, one group followed the template's backward looking approach, while the other focused on an evolving compliance strategy. And now let's talk about the second wave of compliance reports and the plot twists they bring. Alphabet and Apple remain quite consistent, submitting reports that reflect both the past and future compliance efforts while incorporating feedback from the European Commission. ByteDance and Meta land in the middle, updating their 2024 compliance reports to include recent changes. Meanwhile, Amazon and Microsoft take a more static approach, largely reiterating their 2024 compliance strategies. Notably, Amazon's 2025 report is a simply more detailed version of the previous one, meaning stakeholders get a clearer picture of its compliance, but just a year later than intended. And now let's zoom in on the key regulatory provisions that saw updates. The table on the slide highlights areas where gatekeepers adjusted their compliance solutions under the left column versus those where they proposed forward looking solutions under the right column. With that, let's get into the details of the compliance reports from each gatekeeper and the new technical implementations that they have proposed. Spoiler alert, Amazon's lack of innovation on its compliance report means we won't spend much time on its report, as it didn't introduce any significant changes beyond last year's version. First up, Alphabet. The Gatekeepers' compliance report stands out for its willingness to adapt. Every core platform service has undergone some changes due to the DMA's compliance. Take Android, for example, that in line with the unbundling requirements of Article 5.8, it has transformed the initial setup that we all have to go through when powering a new Android device. The compliance changes mean that Alphabet no longer forces users to register through a Gmail account. Instead, a new user sign-in interface will pop up displaying different identifier options so that the user may freely choose how to proceed with the device's registration. Other updates also include tweaks to, for instance, pricing tiers for search query data under Article 611, enhanced APIs to improve data portability under Article 6.9. In my view, however, its compliance with Article 6.3 demonstrates its willingness to try to cooperate with the European Commission based on their informal regulatory dialogue, at least for the particular purposes of implementing this obligation. Way back in 2024, business users voiced their concern about Alphabet's rolling out of its choice screens relating to the search engine and browser services. At the time, the gatekeeper argued, and I remember it vividly, their arguments on the compliance workshop, that they could not ensure that those choice screens reached every single device running on Android because third party OEMs do not always and necessarily roll out all available updates on their devices. Alphabet defended that it had no control over the decisions it adopted on legacy devices. The gatekeeper, however, seems to have changed its tune, and over the last year, it has refined its approach to rolling out the choice screens. For instance, now software Android latest release updates include the choice screens, and Google also conditions their availability as a precondition to approving an OEM's license. On top of that, for those devices running on Android 12, it will launch in approximately May, June of 2025 an over-the-air search selector to roll out the choice screens relating to search engines on third-party OEM device models that have not displayed it yet. In appearance, it seems that the European Commission's interactions with the gatekeeper are also slowly coming to fruition. Apple's compliance efforts show a mix of progress and ongoing friction with regulators. It has made significant changes to its business model since the 2024 compliance report, particularly regarding its implementation of the vertical interoperability obligation under Article 6.7. In particular, it has paved the way for developers to cater for browser engines, which are the beating heart of web browser, on the iOS and iPadOS environments that do not rely on its proprietary WebKit. First, it has eliminated the extraterritorial limitation it had formerly presented before developers. On-device testing of alternative browser engines will no longer be curtailed for those developers located outside the EU. And second, browser vendors will be able to easily replace their WebKit based web browsers with non-WebKit-based browsers via a choice screen solution that the gatekeeper rolls out directly to them. And another big shift comes in data portability under Article 6.9. Against the dynamics of lock-in effects, Apple will roll out in the fall of 2025 a solution helping mobile operating system providers to transfer data from iPhone to a non-Apple phone. By doing this, Apple also reduces end-user switching costs imposed on end users if they wish to exit the iOS or iPadOS ecosystem. Notwithstanding, its efforts to comply with Article 6.3 are unparalleled by any other provision. Apple is progressively making all of its proprietary and legacy apples deletable from its devices, excluding settings and phone. And it has also introduced a centralized default settings page where users can choose from different providers to cater for their email, messaging, or browser apps by default. And building upon these efforts and going back to the topic of browser apps, Apple will also provide higher visibility to developers in those instances where their browser apps are made as defaults by end users, since before that they had no real way of knowing whether they were successful in trying to ignite the end users' change of their defaults. As a matter of fact, the European Commission is also currently considering dropping all charges against Apple on its non-compliance procedure relating to this provision, as reported by Reuters. Moving forward to ByteDance's compliance with the regulation, there have been few updates of its previous compliance report, bearing in mind that the gatekeeper only holds one designated CPS. In particular, and unlike Alphabet, ByteDance reworks its stance towards the interpretation of some of the DMA's provisions, in this case, Article 5.2. In the past, it had defended that the obligation did not compel it to create a new consent moment, since it does not own an ecosystem of services where data can be combined across its proprietary services. Once it introduced in December 2024 its TikTok shop, it decided that it was forced to modify its user experience to introduce a new prompt to enable users to grant consent in the sense of Article 5.2. Once again, the regulatory dialogue the gatekeeper holds with the European Commission seems to be ramping up. Moving on to our fourth gatekeeper, Meta's compliance report is light on substantial updates. For instance, Meta generally declares on the compliance report that it has enhanced its existing internal protocols on the use of non-public business user data without providing further detail. Likewise, it also tweaked its data portability mechanisms by adding more third-party destinations to which end users can directly transfer their data and by incorporating different frequencies in terms of time to perform these same transfers. Bear in mind the European Commission's broader enforcement efforts on the intersection of the DMA with the GDPR's content. Meta's compliance report also exhibits the gatekeeper's efforts in trying to adapt to the regulatory standard. Meta's controversial payer consent model has faced loads of regulatory scrutiny from many different sides. The mechanism forces users to choose between a free service with personalized advertising or to not be delivered such a type of advertising in exchange for a fee. Data protection authorities and the European Commission have voiced their concern on the implementation's collision with data protection principles and also by the potential infringement of Article 5.2. Due to this reason, Meta tweaks the overall user experience and functionality available within its social networks, such as including options for users to select less personalized choices for free on its Facebook and Instagram services. Now, it will be up to the European Commission to determine whether those solutions meet the regulatory standard of the DMA and whether in the end they merit to be fined via a non-compliance procedure. And at the right hand of the slide, you will also find a related consequence of the application of Article 5.2, which Meta has refined with its latest compliance report. Since Facebook Facebook Messenger and Facebook Marketplace are different services in the eyes of the DMA because they were delineated in that way by the European Commission in the designation process, the gatekeeper was forced to unbundle the offering of those services. By doing that, one can, for instance, access Facebook Messenger functionality without having a Facebook account because the end user withholds consent to combine data across the social network. In that sense, Meta has adjusted some of the wording and the registration flow for both Facebook Messenger and Marketplace to comply with the DMA's threshold of effective compliance. On a completely different note, Meta's compliance report also reviews the reference offers that it has designed for both its WhatsApp and Messenger services so that third party messaging providers can interoperate with those CPSs. Although the reference offer has evolved over the last year, this is the first time for Meta to put all of those solutions on paper. For instance, it will notify users every single time that there is an available interoperable messaging service so that they can integrate it into their WhatsApp Messenger services. On top of that, Meta has also expanded its UX on WhatsApp and Messenger by incorporating some of the functionality that stakeholders and third parties voiced out since the first version of the reference offer was proposed. The interoperability functionality works in two distinct ways depending on the end user's choice. Either the user prefers to combine all interoperable messaging services on WhatsApp within a single inbox, or the user can separate those by including them into different inboxes. Additionally, Meta has also expanded its interoperability functionality to other features within its WhatsApp and Messenger services, including replies, typing indicators, or reactions via emojis to the messages sent by the end users. And we come to the final gatekeeper compliance report that I will be analyzing for today, Microsoft. To be completely straightforward, Microsoft was already a frontrunner in detailed compliance reporting in 2024. In 2025, it has imitated the same compliance strategy by introducing additional tenets to its existing technical DMA implementations. For instance, it has stopped the use of some isolated data for purposes that might be in competition with a third party application provider, and it has also created controls to manage the same data in line with the requirements of Article 6.2. For instance, Microsoft engineers developing applications cannot access this isolated data. And therefore, the gatekeeper has also ceased to use that isolated data for A/B future testing. Microsoft compliance report demonstrates, in that sense, its ongoing commitment to try to review and meet its own technical implementation of the DMA in light of the discussions it holds with the European Commission. Following this approach, it has, for instance, introduced two new prompts for its Windows PC OS and LinkedIn CPS, so that its end users may consent to data combinations for the purpose, for instance, of Microsoft's delivering of recommendations and promotions, and LinkedIn's processing of certain categories of personal data for personalized advertising. Subsequent to the legacy cases on Windows Media Player and the tying of its Internet Explorer, Microsoft is also making quite an effort in trying to unbundle all of its services, especially when they interact with the readily available widgets feature pinned on the desktop screen of the users. And that's a wrap for this episode of the Binary Agora. If you'd like to learn more about the topic, check out my Clear Competition Law blog post linked in the description. And if you have any thoughts or feedback, drop a comment below.